So this week on my podcast, I have Charlie Meyer here. He is a trademark attorney, and we are going to pinpoint for all the athletes out there and all the others like me who are representing college athletes in the NIL space, what they should do once they create a logo. So, but first I'm going to have Charlie introduce himself. Hey,
Well,
Charlie, how's it
sure.
going?
Jill, thank you for having me. Pleasure to be
Yeah.
here. Like you said, my name's Charlie Meyer. I am a patent and trademark attorney located in Indianapolis, Indiana. I've been practicing for 26 years or so, and this is what I do full time as intellectual property law, both as a litigator and what we call a prosecutor, which means the process of getting patents or getting trademark registrations.
Mm.
And business advice, licensing, IP related contracts, anything and everything IP related. I like to have some involvement in that. I enjoy that quite a bit. I'm the head of our trademark practice group at Woodard, Imhart, Henry, Reeves, and Wagner, which is an intellectual property boutique firm located in Indianapolis. And like I said, I've been doing this quite a while, and I enjoy talking to people like you.
Oh, you do? Okay, well, here is my big question. Okay, like every time we get a new client, we have them create a logo or some kind of a mark for them to use on product. And I'll just give you an example. For instance, we just got a new client. His name is actually Deshaun Davis, but his nickname is Rams. So he's Deshaun Rams Davis. He's a basketball player. And so as we're talking to him, he said, I would like to create something with a ram inside a TV in a jersey with my number on it, bouncing a basketball, because his domain name is Rams TV. And that's what he is on Instagram too. And that's his nickname. Okay. So with him, I'm like, okay, what do you recommend that we do for him once we get the logo completed and we're happy with it? Because this is a client that we just got. What would you tell him to do, or us to do, really?
Well, there are several things you could potentially do. The first is, his name, Deshaun Davis itself, may be trademarkable for particular goods and services. And if he wants to get that as sort of a core or base mark, he could try to protect that. Then Rams or Rams TV, depending on how he wants to present that, could be a second mark. And it could be independent.
So he would have two marks.
Possibly, or more.
Okay.
That Rams TV could be his trademark for his, merchandise, entertainment services, those types of things. Now, a third option is what we call a logo trademark. And that's what you mentioned with the artwork. And that is where you go into the trademark office and register the graphic of the logo. Now, I'd actually probably put that as a second priority mark because there are, broadly speaking, two types of marks, and those are called word marks or logo or design marks.
Okay.
Word marks are broader and give you better legal protection. Because let's say he registers Rams TV as a word, the registration would then allow him to use it in any color, any graphics, any font, any size within reason, and it would still all be encompassed within the trademark registration protection.
Gotcha.
And in comparison, if you're talking about a logo or a graphic mark, that covers that particular artwork. And so someone could potentially become or use a word that's close while using different artwork, and it would be more difficult, not impossible, but more difficult to assert a logo mark if the only overlap is in the words.
Okay. So him using the words Rams TV in connection with any kind of like apparel or water bottle or anything, does that mean he's protected immediately?
Well, yes and no. To give you
Okay.
the typical legal answer. So, again, broadly speaking, there are two types of trademark rights. What we call common law or unregistered trademark rights. And then there are also trademark registrations. And to step back a second, a trademark legally has two components. One is the mark itself, and the other is the goods or services that it's associated with. So you can't protect a trademark word or logo in the abstract. You have to say it's in relation to certain apparel or certain entertainment services or keychains or headwear or whatever your goods are.
Mm-hmm.
So once you start offering those goods or services for sale, you immediately acquire unregistered common law trademark rights. And something everybody can do, and I recommend it because it's free, is as soon as you start using a mark, put the little TM symbol next to it to
Gotcha.
put people on notice that you are claiming trademark rights in that mark. It's not
Got it.
legally required, but it's certainly a best practice.
Gotcha.
Now, what you can then do if you choose is escalate by filing a trademark application with the United States Patent and Trademark Office and registering your trademark for your related goods and services. And you go through that process. You have to identify the specific goods and services. Obviously, you have to identify the mark. If all goes smoothly, I would say it's been taking about a year, although COVID has slowed the USPTO down, so it's taking a little longer to get your
Really?
registration issued. But during that time, we want you to go out and sell the goods and services because that builds up the reputation of your trademark.
Gotcha. Yeah, that makes sense.
And
So
then
what?
once you have a trademark registration, it's much easier to enforce on online platforms like Amazon or in court. It gives you a lot better tool than just relying on unregistered trademark rights.
Yeah, so we've had a trademark logo for another company of ours called Academic Game Plan, and I've had tons of people use the name, but not necessarily the mark. So you're saying unless you do the name separately?
Well, you'd have common law rights in the name just by using the words.
Oh, okay.
And even if your use is in the middle of a logo, the legal question is it conceptually separable? But basically, if you think about the words and you would use the words with or without the logo as the name of the company or the name of the services,
Right.
then you have trademark rights in those words. And trademark law, the fundamental basis of trademark law is to avoid likelihood of confusion,
Right.
particularly confusing consumers.
Right.
So when you look at someone else who might be using the same or a similar name, you look at first, are the marks similar?
Mhm.
And then second, are the relevant goods and services either the same or related to each other?
Right.
If both of those answers are yes, you potentially have a likelihood of confusion and you're headed down an infringement analysis.
So if somebody does infringe on somebody's rights, because this is a big concern of mine, because it is the university and the state laws are all over the map. They're all different. And like one university might say, okay, you can't use our marks, but you can identify as a basketball player at our university, but you can't use our picture, or you can't use a picture that we've taken with you in it, which doesn't make sense to me, because it's okay for you to use their picture, but not okay. They're in the picture, but they won't let them use the picture. You understand what I'm saying?
I do.
So, and then in the case of other marks, if somebody does infringe on somebody's rights, what is the penalty? Like what are the damages if somebody uses somebody's mark?
Sure. Let me break that down because there are several layers to that question. And hoping I start correctly, Your first question was, can they use the university name, or in what circumstances can they use the university name?
Mhm.
And there is a policy in trademark law that we actually borrow from copyright law called fair use.
Right.
And basically, in the trademark sense, you can use someone else's trademark when you're talking about them, and it's truthful. So if they're truthfully saying such and such is a player at such and such university, they can
Right.
name the university because that's a truthful statement, even though the name of the university is a trademark on its own.
Right. Okay.
The limit on that is sponsorship. The minute the person starts using the university's name in a way that implies the university is sponsoring what he's doing here, that's over the line. That's not fair use anymore.
Okay, so here's an interesting question, because this is the question I've posed to him. When we are pitching to brands, okay, when we pitch to a brand, hey, I have this athlete at this university who is a basketball player, or a football player, or a gymnast, whatever it is, whatever sport they're in. If I use the name to pitch to the brand, I haven't gotten a deal yet. I'm pitching. Does a pitch count or not? This is where we've had confusion, honestly, with every university.
Well, infringement usually requires some sort of use in commerce, and a pitch may or may not be a use in commerce. It's a different issue.
You said
But-
may or may not, though, you see.
Well, it depends on whether it goes into an actual contract. That's the part of it. It's part of, advertising can be infringement, to put it.
Gotcha. Because a pitch
Generally.
kind of is, hey, this is the guy, this is how many followers he has, this is what he's,
Right. But if all you're saying is this is the guy and he's at such and such university, the university doesn't have grounds to object to that.
okay.
Now, if he shows up and starts getting photographed in the university uniform, that might start implying sponsorship. It's going to depend on the context of how it's actually used there.
Well, I understand you can't use it like in an ad for the company,
Right.
but you get where I'm going. I am pretty clear that you certainly, without getting if the university chooses, though, and says, hey, I'm willing to, for this deal, to license our logo and you in the basketball uniform. But if they do it for one, they'll have to do it for all, and that will be a problem, you see. So I don't see universities going down that path very often unless they're going to be compensated in some way.
I would certainly expect them to want to be compensated for something like that.
Yeah.
And that's going back to contract law. I mean, when the player signs up with the university, there's some legal agreements the player's going to sign, which actually answers one of your earlier questions. How can they use the player's image in their photographs?
Right.
And that's because the player has signed that paperwork giving the university permission to use that player's image in the university's photographs. Now, also, when the university takes a photo, they own the copyright in that photo.
Right. Right.
So that's the reason the player can't just make a copy of that photo and use it for their own purposes.
By the way, athletes are doing it all the time on their Instagram.
That's a matter of enforcement.
That's what?
It's a matter of enforcement and whether the
Okay.
university chooses to enforce. I mean, technically, any copy of a photo is a copyright infringement. But most companies are, live in the real world. And if you're just putting it on your social media platform within, a reasonable amount of use, they're not going to object. But when you turn around and start using it to commercially sell products and there's money involved, they start paying more attention.
Yes. Gotcha. Okay. That
So-
makes sense. Yeah, I get it.
Yeah, I mean, it's perfectly common to put things on Instagram, Facebook, all sorts of social media that might be copied from copyright owners.
Yes.
And then it's just a question of whether the copyright owner chooses to make a claim in that situation.
Well, let's say a copyright owner does choose to, enforce that. What are the damages?
Okay. And you asked me a question about trademark damages
Yeah.
earlier.
Yeah. I want to know, okay, now somebody does violate it. What's going to happen? Let's say,
Right. There
what are
are
the potential damages?
well, trademark damages and copyright damages are slight differences in the legal theories. From a trademark perspective, traditionally the strongest remedy that people are looking for is actually an injunction, and that's to stop the use.
Right.
If there's a trademark infringement, you're really not going to agree to a license to allow them to continue to use it. Certainly not as a matter of a legal theory. So when you get into monetary damages, you're looking at, it can be some sort of royalty-based calculation on how much money they're required to pay, as what they would have paid for a license agreement. It can also be the profits that either they made or the owner lost, some sort of disgorgement type of theory.
Mm.
There are various ways to approach that, but basically, the plaintiff is going to look at the amount of damages that they can prove were causally based by the infringement and tie that to the monetary demand.
Okay, so let's say a picture on Instagram, just hypothetically.
Mm-hmm.
I think this happens every day for everybody, by the way, not just athletes. They're using somebody else's picture. How much is somebody's picture worth?
Depends on who it is and what it is. That's a great question.
But if it's a picture of themselves in their uniform at their university posted on Instagram,
and
what are the damages? Do
yeah,
you get what I'm saying?
Sure, if it's posted on Instagram, sort of in a news type of context.
Yeah, like I had, we won, and here we are celebrating.
Yeah, damages there are going to be minimal. That's the damages in that situation are going to be minimal.
Right.
If it's like we've had an example where our local university publishes a calendar with their basketball team on the calendar, and someone went out and started copying and printing their own copies of that calendar, and we had to go stop them from doing that. That's a more monetary based damage claim in that type of situation where we're selling a good, we would have made a certain amount of profit on each sale, and we lost that profit because they usurped the sale.
Yeah, got it. Makes sense. Yeah. Okay.
Yeah.
Wow.
Yeah. Now, in another aspect, copyright law has some extra benefits if you're the copyright owner, that if you have registered your copyright, which is a step you have to go through if you want to enforce it, you have the option to recover what are called statutory damages. And basically, you don't have to prove that you lost money or that they made money. You go to the court and say, pick a number, generally it's between 1,000 and 30,000, and award us that as damages. It's a statutory damages clause. And the real kicker is if you're enforcing a registered copyright, contrary to the normal American process, the defendant pays the plaintiff's attorney's fees.
Oh.
So you really don't want to be on the wrong side of a copyright lawsuit.
Ah, very interesting.
Yeah.
Okay, well, so based on the information I gave you, just like with one client, what do you think the first thing, besides him obviously using it in commerce, do you recommend he registers the name and then registers the mark?
Yeah, I would start with his name, the word mark. His name himself, or at least Rams TV as a word mark.
Right.
Depending on what his persona is going to be and what he's going to promote as his brand.
Well, he's been using that name actually for a long time because his nickname has been Ram since he was a little kid, right?
Sure.
And now that he's become a star basketball player, his Instagram handle is at Rams TV. You know what I mean? That's kind of what he's
Sure. Sure. Well,
himself.
first thing you should go do is go put a TM next to it. Like I said,
Yes.
that's free and that's easy, and there's almost no downside
Yeah.
possible there. Then the second thing would look into registering his name or the word mark in the Patent and Trademark Office. Now, you can go crazy and list every type of good conceivable in the Trademark Office. But basically, you pay a filing fee per class. And like clothing is in one class. Souvenirs are going to be in several. If you went into, keychains or calendars or things like that would be in multiple classes. Then there's also entertainment services. So if they are doing social media entertainment, that could be registered as an entertainment service.
Oh, interesting.
Usually entertainment services for sports are at the level of putting on tournaments or basketball games or things like that. So that'd be more at the university level of registering services, entertainment services for playing games. But I'd look more at the entertainment services from the social media, commentary, whatever the actors do or the players doing from that perspective. And then choose maybe strategically 2 or 3 other classes of what are going to be your most common merchandise, like apparel.
Yeah, apparel probably is the most common. Yeah.
Yeah.
For sure.
Printed goods, posters, calendars could be another big one. And like I said, you can go crazy, but you want to be rational there.
Water bottles. What would a water bottle be?
Water bottle goes under housewares, and the trademark office is a little odd that if housewares are plastic, they're in one class. If they're metal, in another class, and you have to specify.
Oh, really?
But yeah, there's a class that covers basically non-metal drinkware, is what I would put that in trademark terminology. And if you say drinkware, you can cover water bottles, cups, glasses, mugs, various related types of drinkware. If you can.
Oh, so maybe drinkware would be the better classification, you're saying.
Right. Exactly. Sometimes you want to go and list all the ones to make sure you've covered everything. And sometimes you want to take a broad term and encompass all of the potential interpretations of it.
And for each classification, what is it, like $250? Is that what it is to register?
Exactly.
Yeah.
Exactly. The USPTO's filing fee is $250 per class.
Yeah, I've done this before, as you can probably tell. Yep. So this has been so interesting because I've always found trademark and copyright to be really fascinating. But 30 years ago, when I became a lawyer, we didn't have social media. So
that's been a major change, and it's really, social media is often cutting edge law, and usually the statutes themselves have not caught up, and maybe even the courts haven't caught up with the recent issues which social media keeps bringing up. So then we have to go back and try to apply traditional principles to a new factual scenario, which is, as you're saying, fascinating.
It is fascinating. I think it's really interesting. So how does if somebody wants to get a hold of you, needs to get a trademark done, or maybe a university needs representation, my guess is, are a lot of your clients corporations and universities or individuals?
We have a mix of both. We are a boutique firm, which sort of means we're a mid-size firm, and we have a nice mix because of that between corporate. We represent several universities and individuals. I have individual inventors come in all the time and say, I've come up with a new widget. Can I get a patent?
Yeah. Yeah.
Happy to help, all of those and see if we can help people like that. My firm is Woodard Imhart. It's a short
Okay.
name, in Indianapolis. Probably the easiest way to start is by email, which
Okay.
is
What's your email address?
Sure, it is CJ Meyer, which is MEYER, at uspatent.com.
Okay.
One that's easy to remember.
Okay. And does your office have a phone number that they could just call to if they wanted to?
Sure, my phone number is 317-713-4934.
Okay. Well, this has been very helpful, so informational. So if anybody needs help with trademark, copyright, infringement, I think Charlie is the guy to go to. So thanks so much for being on my show. And I'm really glad to get to know you.
Well, I'm glad to be here. Thank you so much for having me. This is
Sure.
fun.